Good afternoon. I want to thank everybody who joins us. My name is Olha, and I'm happy to see all of you here in Ukraine Media Center Current Forum at our Brain Hub, where we will start a very important conversation with you. Today is day 503 of the full-scale invasion of our homeland by Russian aggressor. It's been 10 years of the war, and one of the most important social demands today is punishment of the war criminals, the punishment for the war crimes that were committed in our land, crimes committed against our population, against our both military and civilians. So today we have invited all of you for the presentation of analytic report called What's Happening During War Trials, Interim Findings of the Monitor Report by Human Rights Defenders. Media Initiative for Human Rights did a great job visiting the court proceedings, monitoring those proceedings, and now they present the findings of their work. I want to introduce our speakers today. It's Olga Reshetylova, coordinator at the Media Initiative for Human Rights, Andrii Yakovliev, lawyer and expert at the Media Initiative for Human Rights. Also joining us are Tetiana Kozak, reporter at the Graty media outlet, and Marina Bondarenko, judge at the Darnitsky District Court of Kiev. Good afternoon, dear friends. Ms. Olga, I would like to give the floor to you. I would like to ask you to present the results of this report and describe the matters that were reflected in this report. Good afternoon, dear friends, dear colleagues. Thank you for your attention to this topic. Media Initiative for Human Rights since 2016 deals with monitoring and coverage of the court proceedings related to the armed conflict in Ukraine. And during one of our researches in Criminal Court of the Donetsk region, we've seen that there are many cases being reviewed upon such articles as planning and aggressive war against Ukraine, or terroristic activity, or high treason. And we've realized that Ukrainian society doesn't know anything about those cases at all. And unfortunately, the information about those cases is absent from the media space. There is no discussion around those topics. However, in those cases, we identify the truth about war in Ukraine, who started it, who was committing war crimes during this war, and since that moment we've decided that obviously it's a sign for us. If we've seen those cases, we have to draw everyone's attention to those court proceedings, and since 2016 we deal with all such cases. So it was happening on a volunteer basis before, but recently, thanks to our good partners USAID and the American people who fund our activity in the process of monitoring and coverage of the court proceedings, we've prepared first small analytic report. I would rather say it's an analytic reference. This is what we've called it in its title, that those are only the interim findings about what we've seen in the course since the beginning of the full-scale invasion, since February 2022. I would like to ask our technical team to put the video on the screen so you could see what we see in the courts. We've made a little video about the first award brought up by the European Court over the crimes committed in Bucha. The first award for the war crimes in Bucha. European Municipal Court brought up an award for 9 Russian military. The defendants are the soldiers of the 54th Brigade. Sergei Kipka told in the court that Russians were kidnapping him twice. He was beaten and tortured. He recognized all the defendants. There was a proceedings experiment taken. During the debates, the prosecutor Sergei Shubchik asked for 12 years in prison for the defendants. He accused them of tortures and cruel attitude. The Russians in the court were represented by the government-provided lawyer. I would like to ask the court to appoint the punishment within the article, because I think that the violation of the standards of the processual court were non-existent, because the evidences were provided in a proper manner. There are no justifying circumstances for that I can find. Dear court, Your Honor, I will not repeat the prosecutor. I will not repeat after my colleague. I want to pay your attention to the position of the defendants. The court, for the time being, has no information about the position of the defendants. We have doubts about their redemption. The Judge Mikhaluk approved the award within 2 days. Thirteen persons were pleaded guilty. I was basing myself on the requirements of the law. There are requirements to the doubts. If there are doubts regarding the evidence, they are being interpreted in favor of the defendants. We don't know if they redeemed their guilt, if they recognize themselves guilty. So in this regard, I was asking for a softer punishment, at least half a year less than the prosecutor did. However, I agree that guard should be applied in case of such crime. How well were we informed? For me, the Dutch process of MIHR 17 was an example when the court is located in another country and they find opportunity to inform the defendants in Russian Federation. Obviously, the situation now is more complicated. However, we see both investigators and prosecutors and the court were trying their best to make sure that the defendants know. For the circumstances were not enough for in absentia for publishing in the office, or sorry, in the website of the office of the Prosecutor General. There are objective reasons for this: the absence of the post communication with Russian Federation, and the fact that Russian Federation does not recognize the fact that they commit war crimes. So the court acts in the conditions when Russian Federation does not agree with the war crimes that they commit. They do not agree that there should be investigation going on. And the quality of notice should be high enough, since those awards may be then disputed. That's the first thing. And yet another thing, if we're talking about the application of international humanitarian law, I think that the court has used proper argumentation, and the award can be called motivated and reasoned if it's really identified that those persons are involved in the crime incriminated. And let's not forget the circumstances it was happening in. For example, in Kiev, we have a red alert every day. Every day there are missile strikes, but we have to keep doing this. For example, we collect all the claims, accusations that everything is not ideal, but we have to move on. And as I said, and I will continue saying, that there are certain remarks for such proceedings, specifically in case of in absentia, and in given that we don't have communication with the defendants, we have to keep doing it. But the fact of investigation says that we've documented it, and even if the award will be cancelled or reviewed, the evidences will persist, and they can be used in a new court proceedings, they can be used in the civil lives. They are already documented. Such awards, such judgments may influence the limiting of methods of war where there is no justification for violation, for example, like a random victim of the shelling, or such cases, the number of such cases may be reduced. Thank you very much. That was a small review of one of the court proceedings, and we see hundreds of them in the courts. We've collected all of our findings for the time that we've seen in the court proceedings within this period, and they are all gathered in this analytic report, what's happening during war trials, interim findings of the monitoring report by human rights defenders. And I want to pay attention to the most important articles there, and then I'll give the floor to our experts. The facts we've faced and the other journalists face, specifically the foreign journalists who don't know our practice, the way it happens. I mean, in terms of court proceedings, the access to such court proceedings is complicated because the martial law allows the judge to restrict the access to the court, and it results in serious problems. For example, we were visiting a court in Poltava region with a French journalist, and unfortunately we were not able to visit any single proceeding session out of 5, and no application to the judge's council could influence it. So sometimes there are unreasonable decisions that can be influenced on. And Tetiana, one of a small number of journalists in Ukraine who covered those proceedings on systemic basis, she may tell us more about the way the access to the court proceedings is established in Ukraine. And another finding of ours, it's not a claim to the judges, but the huge overload of the courts. We see a lot of cases upon the articles of high treason and so on, and there are cases of the war crimes committed by Russian Federation during armed aggression, and Ms. Marina can tell us more about this because she faces this overload on a daily basis. So we need to find out how to segregate those important historic processes out of the whole mess of the war crimes. And what we've seen, maybe Andrii can tell a couple of words about that. It's an abnormally quick consideration of the cases when the award is being brought up within 1 or 2 sessions. Sometimes journalists don't make it by then because there are problems with announcements about the court sessions. We don't see announcements about every single session, and due to the complicated access they don't get there. And it's a contrast because before the 24th of July, or sorry, before the 24th of February, we've seen those cases take years. Some of them were considered for 5 or 6 years, sometimes they were postponed. unjustifiably, and we were talking with partners from Vidrozhenia Foundation who produced a colossal analytics about the crimes in Donbass, and one of the remarks in that analytics was that the judges were afraid to come up with the judgments in those lawsuits because there was such a political indefinition, so uncertainty. Many of our international partners were saying that yes, probably there are elements of the international conflict in Donbass, but with elements of internal conflict as well. So we had discussion for a number of years, all the way before the missile strikes of the 24th of February 2022 put a period in this discussion. Sometimes now we see the courts rushing to the judgment, sometimes under the pressure of the community, and maybe sometimes when they want to solve that issue morally for them and they don't need a lengthy consideration of the case. We cannot judge about everybody, but what we've documented is a very hasty judgments, and there is a formal consideration of the cases, specifically in cases of in absentia. We want to stress it, the participation of the parties in such cases, specifically the lawsuits. In the majority of the cases, the lawyers are appointed by the Centers for Free Legal Support. They have quite a formal attitude to those processes in the course, and sometimes they allow themselves some unprofessional attitude. We've heard phrases such as "I'm going to protect the orc" or before the court session, or they were demonstrating the fact that they don't find it pleasant to defend such individuals, and from the moral point of view the society couldn't understand it, but from the professional point of view such attitude of the lawyers is unacceptable. Probably I would like to give the floor to the colleagues. Okay, Ms. Tetiana, so let's talk about your experience, what you've seen during the sessions, and then we'll talk about the legal component. Thank you. So I remember the first session that was announced as the trial of the Russian military. It was in the course of appeal. It's the Solomonsky court, but it's the premises of the Court of Appeals. The venue could not fit all the journalists. There were hundreds of journalists of the cameras who were tracking that lawsuit, that trial, but for me it's more about demonstration rather than about the substance. It was a hasty consideration, just like Olha mentioned. Before the 24th of February, the cases were considered for years and years, and now they are solved within 2 weeks. So it's not a matter of recognition of guilt, not a matter of the evidence, it's not a matter of how the defendants were feeling. And those machine guns that were demonstrated in the course, or automatic rifles, it was more looking like a show rather than the justice. Also, there was a widow of the victim. She felt uncomfortable, it could be seen. She had lawyers who represented her, and frequently in the course there are no lawyers representing victims. The victims think that if they don't have a legal representative, they should not attend the court because it's morally difficult and materially difficult too, because you have to go, you have to wait, you have to stay somewhere for hours, like it was happening during the trial over one of the Russians. By the way, Shashamarin was not the first Russian who was undergoing the trial. I think back in 2015 there was a trial of the Russian citizen, however not for war crimes. As to the openness, for me as a journalist, it's very important the fact that my access to the court is complicated, and those because the cases are being heard in Poltava, in Kharkiv, in Irpin, and you don't always find it out in a timely manner. For example, the trial of Shashamarin was announced, but those trials were not announced, but you don't always make it over there. It's a big problem. You have to have resources, you have to have time for this, you have to have connections to be communicated this information in a timely manner. It's a technical obstacle, but it's important to cover the trials. Then the trials are being held in a closed mode upon the request of the victims, usually in the cases of sexual violation, but not always. There is a case of Kulikovsky. It's not Russian military, it's a DPR soldier who is convicted of war crimes in the prison of DPR. The victims did not want the process to be public, so the court decided to close the proceedings, to hold the proceedings in closed mode. But the journalists, they don't always hunt for some dirty details. For us, what was important is to have the facts documented, to identify that the events or circumstances were really happening. Those stories are very important back then when we look back. I mean, in retrospective, when we try to understand the history, those are the key problems. And for me, I identified this problem that the court sees the recognition of the guilt by the defendant as the main evidence, which means that other evidences are not being considered, and it's a problem. And I don't know how they will work in the international courts, whether those evidences will be considered adequate by the international courts. So this component is like not sufficient for identifying the big or seeing the big picture. For example, if a person is a Russian military, yeah, they may be guilty by default, but it's not enough. For example, they only recognize a guilt, and but for us it's important to understand what was going on and why it was going on, and it influences the quality of the justice that we observe. Well, I talk a lot, but Mr. Andrii talking about the topic of openness of the processes. Can you please tell us whether a court can justify it by the martial law, or isn't it a reason to make those proceedings held in a closed manner? But I would like to say that the justice is like an international guarantee. The guarantee according to our processual codes, it's very important because it influences not only quality of the justice, but also the awareness of the society and of the community, and it may say that it may prevent such cases to happen in future. And obviously when the judge considers a case, they end up under pressure, and obviously it's natural for the judges to make the processes non-public and to switch to non-public mode. There's nothing surprising about that. Our society is very biased, and everybody thinks that if a society wants something, I want to comment that those aspirations, based on the example of one judge from the Supreme Court, you remember that Socrates and Jesus Christ were executed upon the request of the community. So this is what makes us different, that the leaders of thoughts, they try to guide the community after them. So regarding the lawyers and the judges, whether the judge can appoint the non-public hearing given certain circumstances when there is an application from the victim or by the defendant, it may happen, but it should be proportional, just like Tetiana has just mentioned. If we say about the part of the proceedings held in public mode, why it's important to make them public, it demonstrates the transparency of the process, but the majority of cases are reviewed in absentia or upon the avowal of guilt, and all the world will be looking the trial of at the trial of Shashamarin, and they will say that you violate the justice of the process. And when the hearings are public, everybody can find out, even the journalists. If anybody says any critical remarks, you may resort to the journalist investigation and to see whether the hearings were transparent. It's very important, and in our report we pay a lot of attention to it. And without repeating all the statements that were just made, there are not only psychological restrictions for the publicity, but also the technical ones. For example, physically, the cases are scattered across Ukraine, and journalists, the active journalists, they cannot change the location all the time, given the permanent shellings, and visit one hearing in one part of Ukraine and another in another. But there is a video conference option for this. But even for us, it's sometimes very difficult to take part in such a video conference because they are being restricted by the court. There is an explanation by the Supreme Court, but the court still may refuse video conference on legal basis. And talking about journalists or other hearers, they don't have even technical option for this. For example, the video conference process, it contemplates the participation only for the participants of the process, and we have to reduce the regulatory base and to open this option for the free listeners, including the journalists. To avoid turmoil in hearings, we may restrict the right for the listeners to comment. Such options are being implemented in electronic court. For example, when people issue the electronic power of attorney, there is a function of restricted authorities. For example, you can comment or edit or sign the documents. So the developers of this system, they demonstrated in other cases. Now regarding the lawyers, I would like to give a couple of comments. Now let's talk about the work overload of the courts or the abnormal speed of hearings. It's the signal that something is going wrong, and according to the standards of the just court, lengthy hearing or extra fast hearing is a violation of the just trial. So talking about the abnormal speed, we understand that all the rights that the victims may have could not have been provided for. We have to take into account that you cannot agree to the fast trial, because in fact we are under pressure and we will be considered as a country which makes judgments without disputing them. So we compensate the fact that the defendants are absent by the centers of free legal support. They are the centers who enter into agreements with the lawyers. They are regular lawyers. They are not government-controlled lawyers. They are independent lawyers. They are just being funded by the government. And it's important for such lawyers not to be passive. Olga mentioned it, that the lawyers, they are usually passive, and we have to not let this happen. Even the court is obliged to change such lawyers, because in fact we're not going to have the court investigation, but rather it will be something that reminds an element of punishment, an element of revenge, and we have to use all those regular standards, including the proper legal aid and legal support. However, there are cases when the lawyers say acting as defendants. I want to give you the example that Artur Plichno, a journalist of the initiative, told me. And a lawyer was attending the hearing wearing a uniform, but in fact he was wearing a uniform to demonstrate to the society that I am like you, but I'm defending. So we have to fight it, and it's a good example. And when we talk about the defense, when we talk about the competitiveness of the trial as a standard, we need to make sure that the court takes their best efforts to demonstrate and to enable the lawyers to have proper addresses. The advocates, the lawyers should not be passive. Everybody knows Famida, she has her eyes closed, and if she hears only to the accusations without the defense, so what will be the award they will approve? So the lawyers have to balance the defense, that the society should not equal the lawyer with the defendant, so because otherwise everybody will perceive it as a one-sided process. I'm talking about the in absentia cases. Ms. Marina may comment more on this, but I will just put it into words. In absentia cases is a very subtle matter. They envisage that in courts every individual is entitled to judgment. Everyone is entitled to provide evidences in or witness in judgments. But the main principle when we talk about the case of notice, for example, we have to say that an individual had enough information, they were aware of the proceedings, and if it doesn't happen, it's a violation of a just trial. It's not only a violation, but it can be materialized in the leads to the international courts that Russia can go to accusing Ukraine, so they can do it later on, and eventually we will have to pay for it when the international courts corroborate the guilt of the violation of the Article 6 and its compensation, not only at expense of our taxpayers but also the payment for the works of the investigation bodies. And we have to pay attention to those circumstances and realize that we are being severely criticized. I was attending a press conference recently with a number of international experts from Netherlands, United States and Belgium, and they were all talking about the Shashamarian case, and they were all saying, why didn't the lawyer dispute anything? Why they were not saying that it's a judgment for the participation in the armed conflict because the combatants, they have immunity. So there is a number of circumstances to be investigated more profoundly. I'm not going to mention it now, but externally it's perceived this way. Everybody keeps saying that Ukraine cannot judge, but I'm sure that the state of Ukraine can judge. For example, we have a judge present here. Ms. Marina, I want to ask you a question. Mr. Andrii said that there should be a competitiveness in the process in every court. So what should the judge act like when there is no such competitive component? I will answer you in a different way. It doesn't only depend on the judge, but also on other participants of the process. It's difficult for me now. I've heard a lot of problems, but I want to put accents here. Should the court system be so closed, I wouldn't have accepted the invitation by Miss Olga to visit this event today. I will give you just a small comment regarding the statements of the previous speakers about the non-publicity of the processes. It's clear that in case of in absentia, it's difficult to make it non-public. It's one of the fundamentals of the court proceedings. Well, the fact that there were no comments when there were defendants accused, maybe the judges had to make the process not public. So how to catch up with all the court trials in Ukraine? We're not going to solve this issue right now, how to make it on time. I also want to focus your attention on the fact that the war crimes trials are sometimes reviewed very long, sometimes very short, but I want to tell you a different thing. We see statistics from the Office of Prosecutor General. The latest figure is 93,000, but there are no even tens of thousands of those cases in the courts. In fact, the court system is in the mode of waiting. It's in suspension mode, so there are interim findings only. We don't know how the court system will be evolving. When there are tens of thousands of such cases, those problems will be solved as they get the bigger scale. Regarding other questions in absentia, it's something that is used in European countries. We see it in the practice of European Court for Human Rights, but it's not being accepted positively anywhere. And obviously Ukraine is going the same path. Currently we repeat the same path, maybe even on our own. So if regarding the war crimes, we may appeal to the practice of the tribunals, but again, we have to talk about the crimes, because forced military service was not considered by any tribunal. Then for in absentia, this practice is only being built, regardless the fact that the armed conflict is going on for 10 years here, and the active phase is going on for the last year and a half. Still we don't have the in absentia practice built properly. As to the competitive component, our judges are the arbiters, and the law prescribes them to at least formal considers, but the law does not prescribe the judge to inspect or verify all the evidences, or that they cannot say you have to dispute it better or you have to support the defendant better. It's not an issue with the judge. I know about those discussions. I know about that case. It's very widely discussed. And when the judges are being trained, they start with that case. But there are questions to both parties, to the defendants, and about the moments that were not proved completely. Maybe there are questions to the court, but I cannot say about it. So this is my comment regarding the competitive component. Ms. Marina, I would like to hear your professional opinion. What the defense of those suspected of war crimes should look like? We understand that it influences the international, the way the international partners perceive us, the way the international partners perceive our trials. So what it should be looking like? I can only say what I faced. I was lucky with the defense party. I didn't have to emphasize anything for them. There were tens of appeals about justification and so on and so forth. But if there are any other cases, it's more of an issue not with the court, but it's the issue of the lawyers, specifically in absentia cases. The lawyers inside their community, they should build this algorithm whether the defendants were properly notified, were they notified of the pre-court investigation, or as the European Court says, that there was unambiguous refusal to take part in the trial. So this is something that the lawyers have to agree upon in their community and follow that algorithm. Just like all the trial, from the beginning until the very end, it will comply with all the standards. Thank you very much. I would like to give the floor to our esteemed journalists in case they have any questions. Dear friends, do we have any questions on the floor? Please let us know. Please. Thank you very much. It's very interesting to find out what the judges personally feel during such cases consideration. I would like to talk more about the publicity. There is this tool of the telecommunication. It was used more widely before. There is a YouTube channel, the Court of Ukraine. There are videos of the proceedings before the 24th of February. After the 24th, it was decided to make less of those video conferences, and all the video conferences are not being saved, so they are streamed live. You can find it if a court decides to do so. There was a trial of people who were calling for fire during a trial in Kharkiv region, and they were making a stream. You could watch it, but as soon as the session ended, the video conference and the stream ended too. So I think it would be important to retain it for the history. And yet another thing I want to add about the quality. The most high quality process trial that I've seen is the trial of 10 case Kolikovsky in Chernihiv region. The Geneva Convention was discussed there. It was disputed whether the shelling of a residential building was a violation of Geneva Convention. There were investigations and drone measurements and the participation of the engineers. So I've seen an example of a very high quality trial. I understand why those people were convicted, but the minus was that the commander was exchanged during the prisoners of war exchange. Well, I think that there is a consensus among the journalists that it was a positive step. It would be better to interrogate him, but there was no interrogation. And another small remark, I want to emphasize two things regarding the lawyer. I want you to get me right. The lawyer should not be told that they defend the defendants improperly, but the court represents the government, the state, and they are the ultimate institution who reviews the case before it's been submitted to the international courts. And for the standards of international courts, the agent of the government, the judge, should know what to do in case there is no proper defense. When we talk about some ambiguous cases, the judges cannot do a lot there. But in case of Medvedchuk, for example, I'm talking about the situations like that or similar situations when the lawyer violates the rules of the lawyer ethics and they don't exercise the defense properly. I'm not talking about all the cases, but we consider most of the cases in absentia. We don't hear the voice of the defendant, and we have to base ourselves on such positions that we have to defend the defendants the best possible and to have them judged during the just trial. And it's important, as it was already mentioned, that the majority of the cases are the avowal of the guilt is the best option for the court. When people avow themselves guilty, you can quit all the investigations, but those people may further on say that I was pressed upon. Look, even the judges are afraid of such pressure, so what do you want from me? So in fact, I did not avow, and not to make it happen, to ensure it doesn't happen, we have to implement very strict standards to the recognition of the defense and whether the people were understanding what was going on. Are there any circumstances that may reasonably exclude such variants? Thank you. Ms. Marina, I would like to ask you about the emotional component. Ms. Olga said that there were some statements by the lawyers who say that we are all the society, we're both judges and the lawyers, they perceive all those trials very painfully. We understand there is war going on, our military keep perishing on a daily basis, there are victims among the civilians every day. How do we cope with this? How do you manage to cope with it? Well, I make it because that's a component of professionalism. You understand, if you experience everything very emotionally, you may never end any single trial. You may not make it through any single trial. I know that it happens even from, I know there are voices heard from abroad that everybody is traumatized in Ukraine, the judges live in the same society, they end up under the same shellings, but I cannot agree with that, because in the same way you can say that how can a judge consider a murder that happened in the same region where they work, in this, or like in a neighboring building, there is the territorial component when the cases are being considered in the same area, so it may be a component that disputes all the awards brought in other trials. The judges are ready for this. I don't think that if a judge sees a defendant, they will right away get inclined to get that person convicted. No, I don't agree with such statement. Thank you very much, dear friends. Unfortunately, our time is running out. There is a video. I would like to ask our technical team to put the video on the screen. So, to make sure that Ms. Marina doesn't think that we only see the problems in the court. We are the Coalition for 5 AM Ukraine. We were visiting Toretsk, 10 kilometers away from the front lines, and the justice is being exercised there. The shellings come closer, more intense, more scary. The head of the court apparatus told the monitors when the internet is weak, it was impossible to have the trial inside of the court venue. We were walking outside, finding a place where internet is best. We were putting the chairs outside there. We were putting the defendant on the chair. They were given a telephone. We were downloading the video conference application to the phone. We were closing the windows against the rain, dogs, cats. We opened the doors in all the rooms of the court so that in case of shelling, the shock wave doesn't break those doors out. And when the shelling begins, it's very loud, and to protect the life of the court employee who were either inside or outside the venue of the court, we were suspending the trials. The employers of the Dzerzhinsk district court who remained in the city, I think that there is no single undamaged building in our town. Even the schools, even the kindergartens are damaged. Just give me 2 seconds, I will show you where there was a projectile incoming. The court is under the constant shelling. The Russians use even the aviation bombs. Every time after the shellings, the collective of the court clears the debris from the courtyard. This is the incendiary weapon, you know, it looks like a firework falling from the sky. The survey team of the Media Initiative for human rights came to monitor the trial. The shellings are intensified in Toretsk. There were more and more projectiles launched over the town, and to evacuate the children of the court employees, we've taken the following decisions. The employees started evacuating from the town, and the head of the court has undertaken the decision to switch to remote operation since May 22. Mobile hotspot. The listeners join the trial on a remote basis. The procedure is very easy. The survey team of the Media Initiative for Human Rights joined the trial. Can you please tell us, for those who wish to observe the trial, what is the procedure to join to the trial on a remote basis? Well, first of all, there is a telephone number of press secretary in the website of the district court. You can submit an application to the email. What organization wants to join which trial? This application is being registered, submitted to the judge, and if the journalists want to arrive to Torezk, we will get them joined. The judges treated quite well. Are the judges happy to see the observers? Yes, thank you very much. The Ukrainian courts continue to exercise justice even in the conditions of the war. It's a wonderful video that shows us that the professionals keep working under any conditions, and that our Ukrainian people are really incredible. Thank you for joining our discussion in Brain Hub. We want to thank our armed forces for this opportunity to hold events like this. Let's continue working for our victory, and glory to Ukraine.